Welcome to Operational Plans and Intellectual Property. This session is about the invisible assets of an organization, the ideas, brands, designs, and creative works that drive value just as much as physical assets like buildings and machinery. Think about companies like Apple, Nike, or Disney. Their success doesn't only come from their factories, shops, or theme parks. It comes from their logos, their product designs, their films, their characters, protected through intellectual property. By the end of this session, you'll understand what intellectual property is, why it matters, how to protect it, and how to make it part of operational planning. Understanding intellectual property. Intellectual property, or IP, refers to creations of the mind. It includes inventions, like a new medical device, literary and artistic works, such as novels, films, or songs, symbols, names, and images, like the golden arches of McDonald's, unique products, services, or processes, such as Uber's ride-sharing model. Imagine a local cafe with a distinctive logo and a new recipe for a plant-based dessert. The logo and recipe are both intellectual property. If unprotected, another cafe could copy them and compete unfairly. This is why IP is central to operations. It defines what belongs to the organization and protects it from being stolen or misused. Registering intellectual property. Having an idea is not enough. You need to legally register it. In Australia, this is done through IP Australia. Globally, organizations like WIPO protect IP across borders. Consider this scenario. An Australian fashion brand launches a clothing line under a new name but only registers it locally. Months later, a company in Europe trademarks the same name. The Australian brand may find itself unable to expand into Europe, or worse, forced to change its name. Registration provides proof of ownership, legal backing in disputes, and confidence for expansion. Tips to protect IP. Here are the first 3 steps to protecting your intellectual property. Step 1. Start early. IP should be part of your business plan. A tech startup, for example, should file patents or trademarks before seeking investors. Step 2. Understand trademarks. A business name is not the same as a trademark. A business name allows you to trade under that name, but it doesn't stop others from using it. A trademark does. For example, 2 companies might register the business name Green Energy Solutions, but only the one with the trademark can stop competitors from copying the logo and branding. Step 3. Take responsibility. IP protection is not just the legal department's job. Everyone, management, staff, contractors, must know their role. Policies and training are essential. For example, employees should be trained not to share confidential designs on personal email. Step 4. Avoid publicizing your idea. A critical mistake many businesses make is showing off ideas too soon. If you discuss, demonstrate, or even sell your idea before it's protected, you may lose the right to register it. Someone else could claim it as their own. For example, a university research team might present a new invention at a public conference before filing a patent. A competitor could immediately take that idea, patent it, and block the original inventors from using their own creation. Confidentiality agreements are vital when discussing ideas with external partners, suppliers, or even potential investors. Always secure protection before going public. Step 5. IP is for everyone. Many people believe IP is only for big corporations. That's not true. A freelance photographer can copyright their images. A local bakery can trademark its logo. A small app developer can patent a new piece of software. Protecting IP ensures fair competition. It means small innovators aren't pushed aside by bigger players who could otherwise steal and commercialize their ideas. By recognizing that IP belongs to everyone, we encourage creativity across all levels of business. Types of IP protection. There are 4 main types of IP protection, and many businesses use a mix. Patents for inventions, trademarks for brand identity, designs for unique product appearances, copyright For creative works, think of the iPhone. Its hardware technology is patented. The Apple logo is trademarked. The design of the phone is registered. The software and interface are protected by copyright. This layered protection ensures no competitor can copy Apple's product without legal consequences. Patents. A patent gives the inventor exclusive rights to their invention. It can cover devices, substances, methods, or processes, but only if it's original, innovative, and beneficial. For example, Pfizer's patent on the COVID-19 vaccine gave it exclusive rights to manufacture and distribute that vaccine technology for a set period. Without patents, there would be little incentive for companies to invest heavily in research and development. Always use confidentiality agreements when discussing patentable ideas. Sharing too early could void your claim. Trademarks. Trademarks identify and protect brand elements. These can include words or phrases, numbers or letters, logos, drawings, and symbols, even sounds, smells, or shapes. Examples: the Intel Inside jingle, the unique scent trademarked by Singapore Airlines for its cabins, the contour of the Coca-Cola bottle. Trademarks protect the emotional connection with customers, the symbols they instantly recognize and trust. Designs. Designs protect the unique appearance of a product. They cover shape, pattern, configuration, and ornamentation. A registered design lets the owner license or sell it, use it commercially with exclusivity. For example, the design of luxury handbags like Chanel or Louis Vuitton is registered. This prevents copycats from replicating the look, even if they try to use different materials. The difference from patents is that patents protect function, while designs protect form. Copyright. Copyright protects creative works. It applies to films, books, and art, music and sound recordings, software and databases, online and offline publications. Unlike patents or trademarks, copyright is automatic upon creation. For instance, the moment a songwriter records a melody, it is protected. But here's the catch. Copyright protects expression, not ideas. Two people can have the idea for a space travel novel, but only the written story itself can be copyrighted. How to protect your IP. Protecting IP is an ongoing process. Never share ideas without confidentiality agreements. Register your IP as soon as possible. Keep detailed records of how your idea developed. Never use someone else's IP without permission. It can lead to lawsuits. Always include IP clauses in contracts with staff and contractors. For example, a software company may require developers to sign contracts stating all code created during employment belongs to the company. Benefits of IP clauses in contracts. Including IP clauses in contracts prevents disputes. They clarify ownership upfront. They protect employers by ensuring innovations created at work belong to the organization. They protect employees by removing ambiguity about their rights. For instance, universities include clauses in research agreements to confirm whether discoveries belong to the researcher, the university, or a partner organization. Without this, disputes could block commercialization. Intellectual property is more than a legal concept, it's a business strategy. It protects the creativity, innovation, and competitive advantage of an organization. It gives businesses confidence to share ideas, launch products, and expand into new markets. As you build operational plans, treat IP like any other resource. Protect it early, manage it carefully, and make it a cornerstone of organizational success.